Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Today is September 17th, and welcome to class number 9 of our firm's 2024 Virtual HOA Academy. My name is Beth Mulcahy, and I'm just going to be letting some of you join us this morning, as it takes a few minutes to have everybody logged on. So thanks so much for being here today. Good morning, and welcome to class number 9 of our firm's 2024 Virtual HOA and Condo Academy. We teach this HOA and Condo Academy virtually in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. And we're very appreciative of this partnership with these different cities and towns and municipalities. Together, we are creating great free education for board members, homeowners, and property managers. So I'm very appreciative of this partnership and thank them for being willing to sponsor these classes, these free classes for people in our industry who want to learn more. Okay, so just some starting points. My name is Beth Mulcahy, for those of you who might be joining us for the first time, and I'm the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed working with and representing as their legal counsel over 1,000 associations in the state of Arizona for almost 28 years. Today, we're going to start talking about the new laws in Arizona, the new legislative developments from the Arizona legislature in 2024. All of those laws went into effect on Saturday, September 14th. So we want to just give a quick little refresher on that. We're also going to talk about the status of the Corporate Transparency Act, which is a law that probably 99% of you are going to need to comply with by December 31st. And then we're going to move to our main topic today, which is the ABCs of enforcement for HOAs and condominiums. We're going to talk how to best handle violations in your community, fines, lawsuits, refusal of owners to pay, assessments, and owners who make changes to their property but don't get approval first. Big no-no in HOAs and condominiums. We're going to cover all of these topics today. As always, feel free to submit your questions in the Q&A box on Zoom and the comment section on Facebook. All questions will be answered at the end of the session today. We're going to try to end the session right at noon today. And a friendly reminder, today's session is limited to one question per attendee. And we have a lot of attendees, it looks like, today. So great to have everybody here today. Okay, we started the poll a little bit earlier today because we have a lot to talk about. We have the results here that we're going to be sharing with you in just a minute. But if you haven't voted yet, we asked you which city do you reside in, and then let us know your current role for your association. I'm going to briefly talk about the recent legislative session and the new laws. So the Arizona legislature started their session in January of 2024. It was probably the largest in terms of bills introduced and longer sessions that we've seen. All of these bills that we're going to talk about here today went into effect on Saturday, September 14th. Anything we talk about today is the law in Arizona. So let's talk just briefly. I'm just going to do a quick little summary of this, and then my firm is going to be sharing with you just kind of our quick and easy summary that we have on this topic, maybe towards the end of the session today. Okay, so a couple things that you need to know about the new legislation. So the first one is there is a new requirement for meeting agendas in Arizona for regular board meetings. So this applies to planned communities and condominiums. So meeting agendas must be provided with the meeting notice to owners 48 hours in advance of a board meeting by hand delivery, mail, website posting, email, or other electronic means, or posting on a sandwich board at a community center or at the entrance of your association. So bottom line on this, when you send out your notice of meetings now for your regular board meeting or executive session meetings, you also need to include an agenda for that meeting. Okay, next one talks about any sort of fair housing violation language in your documents. So this is a weird one. I don't think this is going to come into play very often, but it's important that you know about it. Maybe your association is one of those that may have this problem. So it applies to planned communities and condominiums. And basically what it says is that if there's any fair housing violation language in your documents, so for example, maybe there's language in your documents that's discriminatory on its face, like it's discriminates against certain protected classes under the Fair Housing Act, like children or disabilities or maybe race or religion. If your association's CC&Rs or other documents contain this language, the board can remove the provisions in the CC&Rs that violate the fair housing laws without a vote of the membership. So it just gives kind of like the power of the board to go ahead and amend the documents that the language that violates the Fair Housing Act is in that document. And you just need a majority of the board to do that. There's also a procedure for homeowners who are upset about language that's in the CC&Rs that may be a fair housing violation. There's a process for them to go to the board to ask for the board to remove it. And if the board doesn't take action, then they have the right to take that action. So kind of an interesting law. Surprised this year we hadn't seen anything, any sort of smoke signals on that in prior years. So surprising that passed so quickly this year, but I think it's a good thing for our industry. Okay, let's talk a little bit about changes to assessment collections. So every single year there seems to be some sort of legislation that puts further burden on associations. This law applies to planned communities and condominiums. And this one is kind of what I would call not a good law that I'm seeing this year, in my opinion. A couple things that are okay about the law that I don't have any issues with would be that the board must exercise reasonable efforts to communicate with the owner and offer a reasonable payment plan prior to a foreclosure lawsuit being filed against the owner. So all of the form letters now that your association or your management company or even our law firm have in place for collecting delinquent assessments, we've now added a sentence that says if the owner wants to enter into a payment plan that's reasonable, please contact us to comply with this part of the new law. The other change to the law is part of the law that I think is not beneficial to associations. And basically what it does is it takes away the right for an association to lien for unpaid assessments, any late fees that are not authorized in your CC&Rs, or any interest charges that may be charged on your ledger for non-payment of assessments, or any self-help charges. So the bottom line on this is these type of charges that were normally lienable prior to this past Saturday, now we have to take the step where we have to go and get a judgment against the owner in a court. And once we get that judgment, then it becomes a judgment lien. So just to clarify, right now, associations can only place a lien on a property for unpaid assessments, late fees that are authorized in the CC&Rs, and collection costs which are incurred by your management company. Anytime that you have attorney's fees, interest, self-help charges, or late fees that are not authorized by your association's documents, those are the type of fees that cannot be liened, and we have to go get a judgment against the owner for those fees and then record the judgment so it becomes a judgment lien. So that's a little bit of a change that is going to affect our industry. And, we've changed all of our forms, and we've had a lot of team meetings in our office to discuss how best to implement that new law. Okay, the next new law is a restriction on transfer fees. So, a transfer fee is like a capital contribution fee. It needs to be set up in the CC&Rs pursuant to state law. There's a specific law that says all the different aspects of the transfer fee language that needs to be in the CC&Rs. They've added an extra thing now that says that you cannot charge a transfer fee when it's a transfer that is for nominal consideration, like $1, and it's between family members or between related business entities. The next law talks about wall-mounted flagpole holders. It seems like every year we get a new law on flags in the Arizona legislature, and this year is not an exception. And so basically what it says, it applies to planned communities and condominiums, and it says that associations may now limit members to 2 wall-mounted flagpole holders on their property. So unusual new law, but that's maybe somebody has 10 or 11 wall-mounted flagpole holders, and under the law, they won't be able to do that anymore. And basically it clarifies that the declaration has to provide a date of method of calculating the date of termination of developer control. So when they're going to be leaving. Most documents already have that, but some association documents may not have that. Now you're required to have that in there. And again, this is going to apply to the developers going to need to comply with this when they create an association. The second part of the law is that declarant control terminates automatically no later than the date on which the second to the last lot in the planned community is conveyed to the buyer. So sometimes it says as long as a developer owns one lot, or maybe there's some other language in your documents, the developer is still in control of your association, your planned community. Well, now it's clear that the declarant control terminates no later than the date on which the second to the last lot in the planned community is conveyed to the buyer. And it also the new law goes on to talk about some protections for developers. So if the developer is no longer in control of the association, running the board, the association is still required to maintain the common areas and not impede the developer's ability to develop, construct, or sell lots. Also, we can't impede the ability of the developer to access and use the common areas. Okay, let's talk a little bit about one that applies only to condominiums. And this one talks about anytime an owner that wants to make a change to their unit in a condominium, if that improvement may disturb owners or residents, other owners or residents, now there's something specific that applies to this. So where I think this is going to come into play is when you have an owner that maybe has carpeting and they want to install hardwood floors. And maybe your documents in your condominium documents don't allow for that. They don't allow second floor units to have hardwood floors. Well, this law is going to trump that. And basically what it says is that if an owner wants to make an improvement or alteration that may disturb its neighbors, the association cannot prohibit it. So we can't say no, even if our documents say no hardwood floors, as long as the owner purchases, installs, and pays for anything necessary to eliminate or minimize the disturbance. So the best probably example we can use on this is the hardwood floor example. Owner on the second floor wants to put in hardwood floors. Owner below worried about the noise. The association can require that owner above to use special sound lessening materials. So typically, we have sometimes they put in cork. There's all kinds of different methods that you can put in the hardware floor, the subflooring to minimize the sound. So the association can require that even, if the owner wants to do something like this, put in the hardwood floors that may disturb the residents below or next to them or whatever. What I recommend best practices would be that association boards should state in writing what those requirements are needed or minimize the disturbance when approving the improvement or alteration to the property. The next new law talks about casitas, ADUs, and guest houses. So kind of interesting development this year. We're seeing powers for these type of things being shifted back to the state level versus the city, town, or municipality monitoring and creating restrictions on them. So basically what it says, the bottom line on this is no matter what the requirements are, whether it's a city, town, municipality, or state requirements regarding casitas, ADUs, and guest houses and the ability to have them, it doesn't matter if our CC&Rs have restrictions on those different potential improvements to the property. So if our documents say no casitas, no ADUs, no guest houses, or our documents say they have to get approval, go through our approval process, we can still enforce that, even though the restrictions on those on a state level have been loosened. Same analysis on chicken coops, which is the next law. So basically what the law that passed this year says that municipalities cannot have a stricter prohibition on backyard chickens and specified under Arizona law. So in the past, maybe we had backyard chicken restrictions, in a city, town, or municipality ordinance. Now it's been shifted to the state. But it doesn't take away our right as an association to enforce any restrictions that we would have on chicken coops, et cetera. And it's kind of interesting just to hear what the state passed this year in terms of the statute. So it says that municipalities cannot have stricter prohibitions on backyard chickens than specified under Arizona law. Municipalities also cannot prohibit owners of a single-family detached dwelling from maintaining up to 6 chickens. Chicken coops must be enclosed and meet setback requirements. And if the lot is less than 1 acre in size, the chicken enclosure cannot be higher than the fence line. Roosters, fortunately, are still prohibited, and the chicken enclosure under this law must be cleaned twice a week. So what's the bottom line on the chicken law is that associations can still enforce restrictions that we may have in our governing documents on chickens, but we can no longer rely on the city code enforcement to enforce any of these new laws on the chicken coops and chickens, number of chickens, et cetera. So associations really should review their documents to make sure that we have mechanisms to prohibit chicken issues if those are a problem in your community, because it will be real important for us to have that information in our documents if we want to be stricter than the state law. Okay, next thing we're going to talk about quickly, that's the end of the state laws. Let's talk briefly about the Corporate Transparency Act. Now, I taught a class yesterday in person at the city of Scottsdale, and we had a lot of questions on the Corporate Transparency Act. So we have our firm's overview of the Corporate Transparency Act, which we're going to be sharing with you shortly if we haven't already. Here's the bottom line on the Corporate Transparency Act. 99.999% of the associations in Arizona are going to need to comply with it. So how do you comply with it? There's a form that you have to fill out that gives the government information about the board members' addresses, they have to provide a form of identification like their driver's license, their passport, and we have to provide that by December 31st to the federal government under this federal law. You're welcome to reach out to our firm if you need assistance with this. I know that there probably are other law firms that are doing this, and I've heard that there's some CPA firms that are doing this and also management companies. The bottom line is we need to file this form by December 31st, 2024. The new law went into effect in January of 2024. All of the paperwork is required to be filed by December 31st, 2024. There are efforts by, different organizations to overturn this law and have it be found unconstitutional. However, I don't think that they're going to be successful in doing that before the deadline to have this filed. So reach out to our firm if you have questions on this or you need help filing the paperwork. It is kind of complicated to do, even though it's a simple form. It's, you have to get the information from all the board members, and then you have to get access to FinCEN, which we have to file the paperwork electronically. So I would say, probably like 95% of associations are hiring a third party to help them with this process. And as part of our firm's process of helping the association comply with this new law, anytime there's changes, we have to update the records with FinCEN, the federal government, within 30 days of a change. Like, let's say somebody quits the board or there's an annual meeting, get new board members. And so as part of our flat fee for filing the paperwork before December 31st, 2024, we also will update as many times as needed during the fiscal year of 2025. So stay tuned on this law. I don't think there's going to be any changes before December 31st, and therefore I do think that every association is going to need to comply. Okay, let's talk about the polls. We had 2 polls this morning, and it was, which city do you reside in? Today, every single city is represented that is sponsoring these classes. So that is amazing. Great job, team. So we have 3% from Avondale, 5% from Chandler and Glendale each, 3% from Goodyear. Mesa is like a record year number this time, 35%. I think that's the highest we've ever had from Mesa. So welcome, everybody. Peoria has 8%, Phoenix 22%, Scottsdale 12%, Surprise 5%, and Tempe 2%. Our second poll question this morning was, let us know your current role. So 74% of you are board members today. That's kind of like a record high. I taught a lot of these classes since 2020 virtually, and 74% board members, that's very high. We also have 7% that are community managers, which is awesome. 14% that are interested homeowners, and 5% that are other. So welcome, everybody. Okay, we also had a third poll question I think that we're going to be launching right now. And one thing that I think my team is going to be launching that shortly, it's what enforcement issues does your association struggle with the most? And so I think that's going to be up on our screen right now. Just give me a little feedback for what issues are affecting your association right now. We give you a couple different choices: long rental issues, parking, maintenance of property, making changes to property without architectural approval, or other. So it'll be interesting to hear what sort of a feedback we get. The numbers are coming in right now, and it looks like we've got really good turnout. So that's great. So I actually see them right on my screen here. So short-term rentals and long-term rentals is 13% of you that are here today see that as a problem. Parking is 31%. Maintenance of property is 36%. Making changes without architectural approval is 49%. That's crazy. So I think I've got some suggestions on that, and then other would be 5. So kind of interesting how different violation issues change over time. I'm guessing, short-term and long-term rentals, that's always going to be an issue. Parking is always going to be an issue. Maintenance of property, I kind of expected that would be high at 36%, but making changes to property with architectural approval, half of the people here today are seeing that as a violation. So we'll want to talk a little bit about that. A couple of things I want to just mention as starting points. We have a great cheat sheet on rental properties on our website. So if you have issues with that and you want to know what the law is, please definitely check out our cheat sheet on our website. All of our cheat sheets are located at mulcahylawfirm.com, and we have a cheat sheet tab on the homepage. I want to mention one thing on parking because I think it's really important for you to hear. If you're an association that's a planned community and you have streets that are owned by the city or dedicated to the city, there's a law that you need to be aware of that is going to take away your rights to enforce on-street parking if you don't comply with it. So remember, there's two things that have to kind of have you fall in this category where it's going to be potentially taken away. Planned community and your streets are dedicated to the public or dedicated to the city. So you need those two for this law to apply to you. Basically, you have to have a vote of the membership to keep the ability to enforce anything pertaining to parking on the street. And we have to do that by June 30th of 2025. And so if you're an association that's in that situation where you're a planned community, your streets are dedicated to the public, and you want to continue enforcing on-street parking, be able to enforce whatever's in your CC&Rs on that, by June 30th, 2025, you will lose the right to enforce on-street parking in your community, planned community, where the streets are dedicated to the city. Another thought would be making changes to the property without architectural approval. Make sure you're pumping out information all the time about how important it is for people to get approval prior to making any changes to their property, and give people examples like anytime you paint your house, anytime you put an addition on, anytime you change your windows, anytime you put a new roof on, anytime you change your landscaping, and just keep pumping that information out all the time to your community. Good communication on that with the form right there, so it's easy for them, and whatever you're sending out is a great way to counter that so you don't have future ones or people are making changes without approval. Let's talk a little bit about our main topic for today, which is enforcement of governing documents. We have some great cheat sheets on our website that I think would be very helpful for you to take a look at. So the different cheat sheets that we have have one called Enforcement of Governing Documents, which kind of gives a really good overview of what your different legal remedies are. And then we also have one on levying and collecting fines in a community association. So we're going to be talking about fines here in a minute as well. But those two cheat sheets would be good fallbacks after this presentation today if you want to do more of a deep dive on what we discussed. Obviously, one of the larger issues facing boards is owners who are not complying with the association's documents. And it's really hard to serve on your board. I know that I've served hard time for 14 plus years. And one of the things I think that's most frustrating for me as a board member is we have so many responsibilities serving on the board, right? We've got to keep our eye on the finances, make sure we have enough money, make sure that nobody's stealing money from our association. We have to keep up with deferred maintenance, and we've got to plan long-term capital improvement projects, right? We have to deal with difficult homeowners who are unhappy about something or who have a lot of questions and who need a lot of our time to keep them, from feeling unhappy about things in the association. And then on top of that, we have enforcement responsibilities for people who aren't complying with the documents, right? So it's like an extra because people don't want to follow the rules or because people don't want to pay their assessments or can't pay their assessments. We have this added extra burden to, pursue those violations because under our documents, we have a requirement to enforce the CC&Rs. And typically these type of restrictions are usually in the CC&Rs or in the rules. Okay, so here are some just common suggestions that we have if you have enforcement problems in your community. So typically, let's just start with like a violation. Let's give an example of somebody who has painted their house without getting approval from the association's board of directors. So typically what we see, it could be anything from parking to leaving your trash cans out to, not maintaining your property. These are all good examples that would be, typical things that we see in our communities. Remember how it usually works is there's two ways that we know about the violations. Either maybe your management company does a drive-through or a walkthrough of your property once a month or once a week or once every 2 weeks. It just depends on what your management contract says. And you get a management company report on all the violations that are currently on the property and what they're doing on them. Or maybe if you're self-managed, or maybe if your management company isn't doing that and the board's more active than the management company, maybe you're getting complaints from other owners about violations on a property, or maybe the board member is just personally witnessing it. Like I know when I walk around my community at night, if I see a violation, I usually take a picture of it and just send it to our manager. So what's the process that we typically follow when there is a violation? So the first thing that boards typically do is they send a courtesy reminder letter to the owner. This is kind of a nice, friendly reminder that, you have a lot of weeds in your front yard and you need to maintain your yard and give them a short time period to correct the violation. In most cases, I would say that courtesy reminder letter results in them correcting the violation pretty quickly. If they don't correct the violation pretty quickly, then the next thing that typically happens is there's a more formal violation letter that's sent to the owner. Maybe the management company sends it, or maybe the attorney for the association sends it, or maybe if you're self-managed, maybe the board's sending it. So the next step is if that friendly letter doesn't do the trick, then we send a more formal letter where we actually start making some threats of, if you don't take care of this, here's what will happen. Maybe the file's turned over to our attorney, or maybe you're going to fine the owner. We're going to talk about fines in a minute. Maybe you're going to exercise self-help. We're going to talk about that in a minute, where the board goes in and cleans up the property. Maybe if it's a serious health and safety issue, maybe we're going to file a lawsuit or go to the Arizona Department of Real Estate to have them a complaint filed there. So there's a number of different threats that we can make in this formal violation letter. One thing I want you to be aware of is that under Arizona law, we are required to put this sentence in every formal violation letter. And it basically says, and this is the language that the Arizona legislature makes us put in a letter, and probably your management company has this in there, our firm has this in there as a form. So basically the language that has to go in the violation letter is, you have the option to petition for an administrative hearing on this matter with the Arizona Department of Real Estate pursuant to ARS 32-2199.01. And so basically, I think what I found in my experience is a lot of the legislation is very owner friendly. And so they want the owner to know, hey, if you disagree with this violation, you have a remedy yourself. And that would be to petition for an administrative hearing through the Arizona Department of Real Estate. So just as a practice pointer or best practices, you need to have that in your violation letters. And if you need that language specifically, it's in our cheat sheet on enforcement of governing documents. You can just go in there and lift it from there if you don't have that in your form letter. Okay, as part of the formal violation letter, you might be putting a thread in there about fines. How do fines work in Arizona? So under Arizona law, we can levy a fine against an owner after giving them, and it has to be reasonable, after giving the owner notice and an opportunity to be heard regarding the fine. And so basically we have to set it up kind of in a 3-step process. So the first step is, we send them a letter saying your trash cans haven't been put away. And, this is an ongoing situation where this has been going on for a long time. And therefore we are going to fine you X amount of dollars if this isn't corrected. That's the first letter, right? And it has to be reasonable. The second step on this is in that letter, we have to indicate that you have the right to an opportunity to be heard. So they get due process. The due process can be handled. They can write back an email to us and let us know their position on this, or they can come to a board meeting if your board wants to have them come to a board meeting, or they can write a letter and send it by snail mail back to the board by a date certain. And so now we've given them notice of the violation. We're putting in the letter, the first letter we send, an opportunity to be heard. And then the third part of this is we wait and see if they respond within the time period. And then depending on their response, maybe they don't respond, or maybe they do respond and say, oh, I'm so sorry. We've corrected it. It won't happen again in the future. Or maybe they have some other pushback on the violation. The board evaluates that as part of the fine process. And then the board makes a determination whether to fine or not fine the owner. So again, on fines, have to be reasonable. And if you're not sure whether it's reasonable or not, reach out to our firm, talk with your management company. $1,000 fine for not trimming your palm trees, not reasonable. The fine should kind of be related in some way to the cost, I would say, to do that. So maybe it's $100 or $300 or something like that. So fine has to be reasonable. We send the demand letter saying, you're in violation of the documents and here's the issues, right? The demand letter is going to have the language that we're required to put in there under state law. We're going to have to tell them if we're going to threaten fines or we're going to actually levy the fine. We're going to say, pursuant to Arizona law, we have the right to fine you. Our fine that we anticipate is $100 or whatever the fine's going to be. You have a right to be heard regarding this fine. And you can contact us by email by 10 days from the date of this letter to be heard regarding this fine. And then you wait the 10 days, and then you have to send, the board considers their response, and then you send out a fine letter if you're going to fine them, or, a thank you for cleaning that issue up and you're not going to be fined letter. So it's a process to levy fines for sure. Remember, on the fines, we cannot lien for unpaid fine monies that are owed to the association. That's been the law for many years. What can we do? We can collect those fines by filing a lawsuit against the owner, getting a judgment in justice court or superior court, depending on how much is owed. And then we record that judgment with the recorder's office, and it becomes a judgment lien. And the owner has to pay it when they sell their property, or we can garnish their bank account or their employment with that judgment to get the fine monies paid. Remember, fines should be used to get compliance. We shouldn't be thinking of this as income for our association. We want people to comply with the documents. We are not counting on income from fines annually to balance our budget. What I always say is, if somebody corrects a violation quickly and they're not a habitual offender, maybe you waive a portion of it or all of the fine as goodwill. But if it's a habitual offender, I would keep that full amount of the fines and make them pay it. And the reality just basically on fines is that, it's expensive to get a judgment in justice court or superior court, because you're going to have to hire an attorney to do that. So we're not pursuing an owner legally filing a lawsuit for a fine that is, $50 or $300. Kind of the threshold that I think our firm looks at is there at least $500 that's owed in fines before we would file a lawsuit on fines only against the owner. Now, lots of times the owner who is getting fined for violations, guess what? They're also not paying their assessment. So sometimes it's an add-on to an unpaid assessment lawsuit that we're filing against an owner. A couple of things. Sometimes some management companies are putting fines on a ledger for an owner without getting a judgment. Almost every management company in the Valley is doing this, so it's not anything new. The only thing I want to mention about that is if an owner challenges that, like let's say that the property's selling and there's, a couple $100s of fines on the ledger, and we disclose the amounts that are owed to the title company. If an owner challenges that and they say, hey, you don't have a judgment for those fines, you will not be able to collect those fines at the close of escrow. So I just want to make that, you be aware of that. Okay, another option, if you have an owner that is violating their documents. So another option that you have, that you can put in your violation letter to them, as we talked about fines, you can also exercise self-help. Self-help is where the board goes in and corrects the violation and then charges the owner for the violation, whatever it costs to correct the violation. So let's say maybe somebody isn't maintaining their yard, and the association, it has to be in your CC&Rs that you can do this. And usually there's a pretty strict notice requirement to give the owner notice that, hey, we're coming in to fix it, and you're going to be responsible for the cost to fix it. The board gives the notice that's required by the documents. It has to be in the documents, again, that you can do this. And then we go in and clean it up, and then we charge the owner for the self-help fees for whatever cost it was to fix up the property. Now, remember, under the new law, we cannot lien for these self-help charges. So it's going to be the same situation as fines. We're going to have to get a judgment against the owner, and we're going to have to record that judgment in order to collect on it, either when the property sells, or we can go after the owner by garnishing their bank account or their wages. Another option that you have that you can be threatening in that demand letter is to consider filing a lawsuit against the owner. Now, obviously, you're not going to go straight to lawsuit without sending at least a couple of violation letters, but these are options that I need to tell you so that when you're making a decision about how to collect on, how to enforce the violations, that you have at your fingertips all the resources. So filing a lawsuit is going to be for more serious violations that have been in existence for a longer time. And basically, it may be the only alternative to get somebody to stop violating the documents. In order to file the lawsuit, we file a complaint and a request for a mandatory permanent injunction against the owner. And basically what that does is we're asking the court to order the owner to do this, to fix it, to repair it, to not do something if they're doing a violation that's, like a nuisance to the community. If it's like a health and safety issue, we might be able to get in front of the judge under a TRO, a temporary restraining order. And we have a hearing regarding that TRO, usually within 30 days of filing the lawsuit. But again, it has to be like a health and safety issue where there will be irreparable harm if we don't have the court intervene and help us get the owner to stop doing something or to do something. Otherwise, if it's more like a standard violation, like it's lack of maintenance in your association, or maybe they painted their house the wrong color, usually it's going to take at least 4 to 6 months before we get in front of a judge to have the judge hear the case, whether it's by motion or maybe a status conference in front of the judge. So what the end result, if we file a lawsuit, is that we will get an order from the court compelling the owner to do or not do something. And we ask the court for attorney's fees as part of that lawsuit. And, that judgment would say the owner's got to do this or not do this, and they have to pay our attorney's fees and our costs incurred in enforcing the violation against the owner. Again, lawsuits are kind of something that we aren't doing as much because it has to be like a serious violation that's been ongoing for many years. But it is something we keep in our toolbox, is something that we can use to handle violations in your community. And we probably file a couple of these a month on behalf of our clients. There's another option too that I want you to be aware of, which is the ADRE option. So the State of Arizona Department of Real Estate has an arm that was set up by our legislature to hear disputes between owners and associations, or associations and owners. So how this can be used effectively if you have a violation and you want to enforce it against your owner is you can go to the ADRE website, and we're sharing the website with you now, and you fill out a complaint form as the association, or if you're an owner and you have a complaint against the association. Basically what happens is in a very short time period, you have a hearing in front of an administrative law judge. So this is like a really fast way to fast track having a hearing in front of the judge where the judge can hear about the violation and make a determination. There is a filing fee, so it's per issue, it's $500. So if you just have one issue, it's going to be $500 filing fee. If you prevail, you get reimbursed that $500 filing fee. If you lose, you don't get the money back. And I found it to be, a fast and inexpensive way to get a quick answer from a judge on an issue. Now, they don't have, these administrative law judges don't have the same powers as Superior Court judges would have in a lawsuit. So basically, we're just getting a ruling saying this person is in violation of the documents. Basically, it's just a piece of paper saying they're in violation. So it has limited usability in that it just is a judge saying they're in violation. If you need to actually get them, and then they'd have to voluntarily comply with that. If you need to force somebody to do something, you should go the lawsuit route. And if our firm's advising you on this, we'll be giving you tips and suggestions on this, the entire process from the first demand letter. And then also if you have to go forward, if the demand letters aren't working and now we've got to go to a lawsuit or the ADRE, we're going to be strategizing with you through the process to say, okay, I know the personality type of this owner. I don't think that going to the ADRE is going to work. I think we've got to go to court in Superior Court and get a judgment against them, forcing them to do it, because if they don't do what the Superior Court judge tells them to do, they'll be in contempt of court and they'll go to jail. And if you think that doesn't happen, it does happen. I've seen it happen in my practice area before, not very often, but if somebody's in contempt of the court's order, it is a remedy that the court has to get them to comply. One little differential between lawsuits in Superior Court and the Department of Real Estate with regard to attorney's fees. So in a lawsuit, I already mentioned that we are going to get a judgment. If we prevail in the action, it's very likely that we'll get a judgment for all of our attorney's fees or a large portion of our attorney's fees. In the Arizona Department of Real Estate hearings that they have, they do not award attorney's fees to either side. So if you're going the route of the ADRE, you're not going to be able to get your attorney's fees recovered. So you just need to know that going in. And again, our firm strategizes with our clients on this every step of the way, the pros and cons of lawsuit versus ADRE. A couple things just to kind of tie this up in a nice little box at the end of this, subject. So when we're talking about enforcement of governing documents, the main things, just a refresher that you want to think about, are typically you send a courtesy reminder letter. Then you move to a formal violation letter if they don't correct it. The different remedies that you have to get them to comply are going to be, you can fine them, and you can go in and do self-help if it's in your association's documents to do self-help. Fines are set up by state law, You don't need to have a fine policy, although you can, and many associations do, but you're not required to have a fine policy for your association or to have fines mentioned in your documents. State law gives you the authority to fine as long as you're following that it's reasonable and you give notice and an opportunity to be heard before you levy the fine. If you're doing self-help, remember it needs to be in your documents and it's collected in the same manner as fines. So we've got to get a judgment to collect on those self-help charges. Remember, there's two different, more legal options if they still haven't complied after sending those violation letters. That would be a lawsuit or going to the state of Arizona and filing a complaint with the Arizona Department of Real Estate. If we have an owner that is not complying with our association documents, here's our plan from A to Z. Okay, let's talk a little bit about what are some common violations that we see. So rental properties is a big one. And we saw that just with our poll today. 13% of you said, hey, this is like a really big issue in our community. We have a great cheat sheet on how to effectively work with rental properties that we're sharing with you. That's kind of a great 411 on everything you need to know about what the law is on rental properties. Just a quick little primer on some important things on rental properties. So the law has changed over the years in terms of what we can require the landlord owner to give to us as the association when there's a tenancy in the association. So really there's only three things that we can ask the owner to provide to us. So the name and the contact information for the adults in the unit, the time period of the lease, including the beginning and the ending dates of the tenancy, and then a description and the license plate numbers of the tenant's vehicles. If you're an age-restricted community, like a 55-plus community, we can also ask that they provide a government-issued identification with a photograph of the tenant and confirmation that the tenant meets the association's minimum age restriction. So at least one of the tenants in that particular unit or lot would have to be age 55 or over if you're a 55 and over community. So just kind of important to remember, if you have rentals in your association, we can only require certain things. And I just went through those from the renter. This is all listed on our cheat sheet if you want to go back and look at them a little bit more. You also, some fees on rentals. So we can only charge a fee of $25, like a rental fee of $25 for any change in tenancy. And so that's important for you to be aware of. You cannot make it larger than that. That's what state law says. If they don't provide the tenant information that I just went through, the 4 areas or 3 areas plus 4, if you're a 55 plus community, we can charge a $15 late fee. That's the maximum. So it's really important to know that even if your documents say that you can charge more than $25 for each change in tenancy, you can't, because the state law, which applies to planned communities and condos, limits you to the $25 charge for a change in each tenancy. And if they don't provide it, you can only charge $15. You can't go off charging some high amount of fines if the maximum is $15 if they don't provide that. Let's talk a little bit about short-term rentals, because that seems to be a big issue in our communities. Remember that when we're dealing with rental properties, you have to check what your documents say about them. So, if your documents prohibit short-term rentals, then you can enforce a prohibition on short-term rentals. If your documents don't say anything about rentals, owners can rent however they see fit. If your documents have a provision like all leases must be a minimum of 30 days, you can enforce that in your documents. The most common things that we see with rental properties, in terms of, the issues that we see would be renters that don't have information about what the CC&R say or what the rules are in their community. So making sure that anytime there's a tenancy or a rental tenancy in your community, making sure that the landlord or maybe even the board is dropping off the association's rules and the documents so that the landlord and tenant are both aware that, hey, the tenant needs to comply with this. What do we do if we have a bad tenant? Meaning the tenant is just violating the rules all the time. We go to the owner. We make it hurt in the owner's pocketbook. We document what the tenant is doing. We notify the owner. We fine the owner if the tenant's behavior doesn't stop. All of these are really good suggestions in terms of dealing with the bad tenant. If your association's in that situation, please reach out to our firm. We have been enormously successful in getting the landlord to reality that they have to make their tenant comply with the documents. And basically the reality on this is, hey, if you don't have your tenant comply, what's going to happen is it's going to be very expensive for you, because there's going to be legal fees that are going to be charged. We're going to fine you. We may have to file a lawsuit against you. and you're going to have to pay all of this. And, we know that you're renting your property because you want to make a profit, or you want to have it as a placeholder in case you move back here in the future and you don't want to give it up. But the bottom line is this tenant's costing you money because they're violating the documents, and we're using all of our enforcement means to get you to comply. And I really cannot think of maybe a handful of times or a quarter of a century where if we were involved and we have the ability to contact the landlord owner, that we haven't gotten the landlord owner to take the action that they need to get the tenant to comply. So keep that in your back pocket if you have a problem with tenants, or a good resource for you to help you get that tenant to comply via the owner. Okay, another common enforcement problem that we see is parking problems. Here's our kind of 411 on how to deal with parking problems. Number one, check your documents. What do they say about parking? Like, does it say no on-street parking? If so, then you can enforce it. The most common parking issues that we see as a law firm that helps associations is overnight on-street parking, RV, campers, boats, commercial vehicles, trailer parking, in the driveway or maybe on the streets. All of these are the most common parking issues. Or maybe a family has 6 cars and they only have a 2-car garage and 2 spots in the driveway. So those extra 2 cars are overflow into the street and they're violating the association's documents. Again, just use the same procedure that we've talked about here today. Enforcement letters, fines. I would be really careful about exercising self-help in terms of towing, unless your documents allow you to tow, because towing usually results in some sort of a big disagreement. And usually there's a lawsuit if a car gets towed, and they feel it's been damaged. So I'm kind of wary on the towing. It can work in certain circumstances, like if somebody's parked on a red curb and it's limiting our ability of the fire department to access the fire hydrant, of course, then we're going to be towing. But just towing a car that's parked on the street in the middle of the night, I'd be a little more wary of doing that. So this is another big parking issue, because a lot of these parking violations occur at like 2 a.m, right? And we don't typically have a board member or an owner who is, we don't have anybody out there looking, right? So typically, we get owners reporting these parking violations. Maybe your association has a security patrol that comes through every night and puts those bad stickers on the windows, telling people they're in violation of the documents. And those are very effective, by the way. Those stickers work. Or maybe your management company is patrolling once a week or something like that in the evening. So how are you going to find out about the violation, and then who's going to enforce it? Typically the board is going to enforce it, but we have to find out, who's going to be patrolling at these times where these violations are easily discoverable. And then really, how to enforce it. We talked about for parking violations, it's letters, it's fines after notice and an opportunity to be heard. Towing is kind of sticky. We talked about that. Be careful on towing. Putting those really hard stickers to get off on your window, on the window, like the passenger window or on the driver's window, is a good way to get people's attention. Just, you want to make sure that the stickers don't in any way damage the glass. Booting the vehicle, that's another option. I recently saw in an association where people are putting these things on the windshield so that they can't see, but there was some sort of a hack to get those off. Actually, my association was looking into that, and we Googled it, and there's a YouTube on how to easily get them off. So you want to just kind of really think through on these parking violations. What's the best way to get compliance? And reaching out to our firm, we can help you if you have a parking problem and help you come up with a plan and a strategy to help you on this issue. What about failing to submit architectural applications? This is a big one. Like you said, today we had 49% of you have this issue. So let's take a few minutes and talk about this. Failure to obtain architectural approval can look like this. It could be not painting without getting approval, putting in a new garage door, putting in new windows, adding a bonus room, moving around walls, maybe converting your garage into a living space, putting up a fence, landscape modifications, putting a gate in front of your entry into your property, RV gates, golf carts, concrete pads that are for golf carts. These are all examples. So what I would do is first, we always check the documents to make sure that whatever they did need approval. Sometimes it just says changes to the building need approval, and it doesn't talk about landscaping or the concrete pad for the RV. But most of the times, everything does need approval. What's the best way to handle? Just follow the little checklist we gave you here. Contact the owner, through a courtesy reminder letter or a violation letter, ask them to submit for approval through the architectural committee. It becomes sticky if they've already done it and, they submit their approval form and then we deny it, then you may need to get the association's attorney involved. A common question we get is, does the board have to approve something just because the owner already did it? No, you don't. It does add a layer of difficulty though, because if whatever they did is really expensive, they're not going to want to remove it. We may have to go to a lawsuit to get them to remove it. And again, it's just the same remedies that we've talked about before. We send the letters, we fine the owner, we have potential to go to a lawsuit in Superior Court or go to the Arizona Department of Real Estate. What about failing to maintain a property? Another very common issue. 36% of you on this call today have this issue. What are some things that we can do? We can send the letters like we talked about. We can exercise self-help if it's in your association's documents. We can file a lawsuit. We can go to the ADRE. But the most important thing on a lot of these violations is having photos to document what the current state of the violation is. Because if I'm your lawyer and I'm going to court for you, the judge is going to ask me, well, what does it look like, yesterday? And we'll need a current photo to document the violation. Okay, our last subject today before we go into the questions, and it looks like we have a good, healthy amount of questions, which is awesome, is talking about unpaid assessments and what's the best way to enforce owners that don't pay unpaid assessments. I think really the key thing that I want to remind you of is take a proactive approach to collecting delinquent assessments. And that means getting on them early. We're starting to see a change in the economy. Post-COVID, it was kind of odd. There was so much money being pumped into our economy that a lot of people paid up what they owed to their associations. And we didn't see a rise or increase in the number of delinquencies, from like 2020 to, let's say, beginning of 2024. But we're starting to see an uptick in the number of association owners who aren't paying. And the one piece of advice I can give boards here today would be get on those early. Do not let those jump up to a high amount. So you should be sending a letter once the assessment is 30 days past due, and maybe another reminder letter at 60 days past due. Then lien for unpaid assessments only. Remember, late fees, if they're authorized in your CC&Rs and collection costs, lien maybe at the 60 to 90 day range. And then bam, send it over to your attorney to start pursuing the violation. That's really the most, expedient and prudent way to handle unpaid assessments, because the associations that just sit on them for 3 years, 4 years, 5 years, it makes it so much more difficult to collect on that debt. So really the best piece of advice I could tell you about collecting delinquent assessments is jump on them early to get them to pay. So right away, and let them know that, hey, there's consequences. If you don't pay, it's going to cost you, right? Because you're going to have lien fees, you're going to have collection costs from the management company and attorney's fees. So being proactive on collecting delinquent assessments, I think is very important. Communicating with your owners. So keep reminding owners that they need to pay their assessments, send out, reminders in your newsletter, talk about it at the annual meeting, talk about it at your regular board meetings about how important it is to pay your assessments on time, because we create our budget with the expectation that 100% of the owners are going to pay. So if not everybody pays, we have a shortfall and we don't have enough money to pay our bills. When a file is turned over to our firm, and I think this is really good advice, so maybe the association tries to collect it by sending demand letters, a couple demand letters, and then maybe they put a lien on the property, or maybe they ask us to put a lien on the property. And once the file is turned over to our firm, what we do is we do credit research on the owner to determine what's the best way to collect the debt. And we do that before we spend any other money. Why do we do that? Because we want to first verify, is the owner in bankruptcy? If they're in bankruptcy, legally can't take any action because of the automatic stay of the bankruptcy. Second, we want to find out, are they employed? Do they have equity in their property? Do they owe a bunch of money to other people? Are they teetering on, falling apart here? We look at their credit evaluation. This is all really great, valuable information. And it's something that our firm does that really sets us apart, I think, from our other firms that do this. We don't just go into any situation without a strategy, right? So we want to have a strategy. As soon as that file is turned over to our firm, we look at, okay, this is the way that we're going to find the path to collect the money. And this is what this person's credit looks like. And how do we do that? We have a number of online resources that we subscribe to or that are free. So we double check to make sure they're the owner. We look to see if they're paying their mortgage. We look to see what their, value of the property is versus how much is owed on the mortgage. We look to see if there's a trustee sale. If they're not paying their mortgage, maybe the bank's foreclosing. We look to see if they filed bankruptcy. We look to see if they are employed. And are they currently employed? Is it old employment or are they actually still working today? We look to see, do they have any other judgments against them? These are all things that we're looking at on the front end. And then we come up with our strategy to collect the debt. And to be real with you, with this new legislation that just went into effect on Saturday, we're kind of changing a little bit our strategy. So once the file is turned over to our firm, we do this credit evaluation. And then we're going to come back to the board and we're going to say, okay, we're going to send one letter. And the letter is, of course, going to include the language about if you want to do a payment plan, you're welcome to do a payment plan. But after that letter, then we're going to make a decision because under the law, we can't lien for unpaid attorney's fees. So we don't want to rack up a bunch of attorney's fees because we can't collect them unless we have a judgment, right? So we're sending a letter from the law firm is going to be our standard procedure. And then if they don't pay within 30 days, then we either go to justice court to get a judgment against them. When we go to justice court, it's typically because we know we can get the money by traditional means, meaning like they're employed and we can either garnish their wages or their bank account. That's going to be our threshold if we're going to go the justice court route. And we just get a piece of paper. We record that piece of paper saying, I have a judgment against Johnny Appleseed. And then we go straight into garnishing their bank account or their wages. If we don't have like an easy path to employment or we know where they bank and, they're solvent, then we go the foreclosure route. And basically in that case, we're only foreclosing if the owner has equity in their property, significant equity. So at least 30 or 40 grand in equity in their property. And we foreclose on it. And basically what that means is the court orders that the property be sold and that the association get paid. Now there's two outcomes that typically happen when there's a foreclosure. Either the owner pays up, they find the money and they pay up, or it goes to a sheriff's sale and a third party buys it and we get paid in full from the third party. And so there's lots of remedies for owners that aren't paying assessments. Keep an eye on this going forward because we anticipate that in the rest of 2024 and 2025, we're going to see an uptick in the number of delinquencies in your associations. So we're really encouraging you to be proactive and take a proactive approach on collections as the economy is changing. Okay, looks like we have a great number of questions. So we covered a lot of materials today. We talked about all the new legislation on the state level. We talked about the Corporate Transparency Act on the federal level. We talked about enforcement of governing documents and what we can do if an owner isn't complying with the association's documents. And then we talked about how to collect delinquent assessments and what our strategy should be going forward. Now we're going to flip over and talk about 37 questions that we have from today's class, which is awesome. Okay, let's start with our first question. Let's see, it's from a president of an association. Please tell us what will happen if we cannot get enough people to have a board. Well, the scary reality of that is if you can't get people to have a board, you're going to have a receiver appointed to run the affairs of your association. So that's scary. That's not an outcome that you want for your association. If you're in this situation right now, reach out to our firm. We can help you. We have a letter that we send on our letterhead to all owners, and you can disseminate it. We just write the letter. And basically, we explain to them, this is what happens if people don't run for the board and we don't have enough people to have a quorum of the board. And the court will appoint a receiver to run the association. The first thing the receiver is going to do is they're going to levy a special assessment that the court's going to approve that says that each owner must pay for the receiver. So it's like not even paying for an improvement to your community. It's just paying a receiver to run the association. So in addition to it costing more for everybody to have a receiver, it's also going to affect your property values because how are you going to be able to sell your property if a court-appointed receiver is needed to run it? It's just not a good situation for anybody. Okay, the next question. What is the difference between a vote versus a consent to make a change on a community document, such as a CC&R or an amendment? Does Arizona statute require the board to set a time limit to get results from the community members? So this is an amending CC&R's question, and the person that's asking this is saying, so what's the difference between using just a ballot voting yes or no versus a consent form, which saying I consent to this amendment? Honestly, there's really not much of a difference. probably you're using a consent form because your documents, require you to obtain a consent of 75% of your members. That's just a linguistics thing that you're using. Does Arizona statute require a set time limit? No. But typically what we see is we strategize, like how active are people in your community? Like sometimes I have boards say to me, I think we can get this done in 30 days. And they say, well, we only have 20 owners and we'll just knock on everybody's door and we've gotten things done quickly in the past. And then maybe 30 days is enough for that community. But for larger communities, we really probably want to set it at somewhere between 3 to 6 to 9 months to get the votes that we need if we have a high percentage of approval that's required and a lot of votes. But there is no Arizona statute that puts a time limit on it. Okay, question 3. Can our entire board conduct a tour of the D inviting the residents? Is it a meeting under the law? I'm not sure I understand that question. Can our entire board conduct a tour of the D inviting the residents? I'm sorry, I don't know what you mean by that. So if you're still on, submit in through the Q&A box a clarification on that and I'll answer it at the end. Okay, question number 4. Our CC&Rs and rules and regs do not address a homeowner who wants to put flooring and a gazebo on his roof. How do we address? Well, if I had to guess, I don't know if you're a condo or planned community, but one of the things that I would say that how I would address this is I would make that person submit an architectural approval, and I would require that person to obtain a written report from engineer saying whether or not the load, the roof could take the load. I mean, I think you can also consider this like, hey, is this something that we want in our community? Like, is this something once we allow this, if we do allow this, is it something that we'd be okay with? This 50% of our owners had it. So, just some things to think about. This should be done through the architectural process. You may need to talk to your attorney. You're welcome to reach out to our firm if you have questions on this, just to determine like, hey, is this something that we really want? And if it isn't, how are we going to word the disapproval so that we're protected if the owner challenges it? Okay, next question. What if they post the 48 hours advance notice of the meeting and agenda on their website and I don't see it? Well, let's go back up to the law. I think that it gives many different ways where you can post the agenda. It can be by hand delivery, mail, website, email, or other electronic means. So it's pretty open-ended how they can post the agenda and the notice of meeting. So as long as they comply with that, you just need to be checking frequently if you're interested in association issues so you don't miss anything. But if you miss it, there's really the association's not at fault that they complied with how they posted it in accordance with Arizona law. Okay, question number 6. Assume an HOA that is seeking bids from contractors for major repairs to common area property that are motivated by safety and security concerns. So you got an HOA looking for bids. They got a major common area repair because this repair is needed because there's health and safety issues. Got it. A majority of members object to the repairs. Okay. Assume that the objecting members contact bidding contractors and in attempt to dissuade bidding and attempt to intimidate on-site contractors to delay or stop work. Ooh, this sounds like a lot of dysfunction. So we've got the board getting bids for something that really needs to be done because it's a health and safety concern. We've got a group of homeowners who don't want it, who are like creating a disruption by, telling people not to bid on it and then interfering with contractors that come on site. Okay, probably what's happening here, if I had to guess, is that nobody wants to come on your property because they don't want to deal with this. They don't want to do the work because it is, a problem. So you're saying now, further assume many contractors decline to bid because of the members' interference. To what extent, if any, do such members have legal exposure in the event of harm to other members by reason of incomplete safety and security repairs? I'm sorry to say this, but probably no legal exposure. If somebody, gets hurt because there's a big crack in the tennis court, right? The board's going to have legal exposure, but not the person that, is creating all this interference in the association's property. I think the bigger question is, why aren't you as a board sending cease and desist letters to these owners who are creating all these problems? I think that would be a good idea here. They really have no right to do that. They're interfering with the contract and they're legally, it's an issue legally for them to be doing this. And as a board, I think, you probably do need to get some legal advice because you really do need to address these issues. in terms of the health and safety issues, and then the problem homeowners who are harassing the contractors. And I bet they're harassing the board too. So reach out to us. We've helped many associations with problems like this. And I can assure you, we can give you the tips and tools that you need to make this a much better situation. Okay, question number 7, regarding the form to comply with the Corporate Transparency Act. Did I read somewhere that only one board member's info will need to be recorded on the form if the board gives approval at an open board meeting? We do not agree with that. It's all board members' information needs to be submitted. I'm not aware of any sort of loophole that just says it's one board member. Question number 8. Is there a common or average amount homeowners are forced to pay of an insurance deductible? And doesn't the HOA have to pay the portion that is common property? So if I had to guess, you're probably a condominium based upon the language of the question. There isn't really a common or average amount owners are forced to pay of the deductible. I mean, we just look at it on a case-by-case basis. Like if, let's say you have a fire, you're in a condo, you have a fire inside your unit, and there's a $10,000 deductible on the association's policy. In the condo, the association's insurance is going to be primary, and then your insurance is going to be secondary, likely from the paint in. It's going to be your responsibility. So typically what will happen is if it's your fault for the fire and the association is in no way responsible, you're going to pay 100% of the deductible. But if it's something different, like let's say it's a common area pipe in the wall that bursts adjacent to your condo, it's not in the airspace of your condo, you aren't required to maintain it, then the association typically is going to have to pay that deductible. So we just look at the facts and then determine who is going to pay the deductible. In some cases, associations CC&Rs talk specifically about who pays the deductible and the percentage, but that's very rare. Okay, question number 9. Will your firm handle the CTA filing for HOAs that may not be a client? So yes, we are. And we have many CTA filings for non-clients and for clients right now that are in our pipeline. Is this a standalone service? Yes. I ask because I'm not sure if the other firms my associations may use will offer this service. So we would be happy to help your association with this. If you reach out to me at mulcahylawfirm.com, we can give you the package price for us to file the Corporate Transparency Act paperwork. It's due by December 31st, 2024. And then as part of that package, any changes to your information over the next year, so between January 1st, 2025 to December 31st, 2025, are included in that package price. So it's a smart deal because you just one time you pay it, we just handle it for a year. Okay, next question. Number 10, we've had our open meeting to maintain control of the public streets in the community, which is a law I talked about earlier. Who or how do we submit the documents that satisfy the HOA to maintain street control? So great question. So I think you need to reach out to our firm because there's a specific process you need to follow. So hopefully you handled the meeting correctly and that you got the votes that you needed at the meeting. And then the next step is to have the board sign a document that's recorded with the Maricopa County Recorder's Office, indicating that you took the vote, that you got the requisite percentage, and you are filing it to comply to continue to be able to enforce, issues with your streets. Okay, number 11. Can a condo HOA with a single garages assign parking spaces for each unit based on the number of bedrooms for the unit? So short answer on this is yes, if it's in the CC&Rs. So typically the assignment of the parking spaces is in the CC&Rs, or maybe it's in the owner's deed. But after the fact, doing this is something that would be very difficult, and you would probably need to do an amendment to your documents to do that. Question 12, regarding the new ADU legislation, so like on guest homes or casitas in the back of a property type of thing, what happens when an owner starts construction without the required HOA approval? The construction can be seen from the neighboring property only, but the CC&Rs state that if something can be seen from a street or a neighboring property, it requires HOA approval. ADU was at the framing stage when the neighbor reported it, and attorney told us that we had to be reasonable as the ADU was already so far along. I don't agree with that. I think that at any point in the violation, even if it's built, we've seen cases where a guest house had to be torn down. If the owner had submitted for HOA approval, the board would have unanimously turned it down. So what is to keep owners from proceeding with construction knowing that the HOA potentially has no remedies? So I think the bottom line on your question here is I would pursue this. If it's not something that you would allow, I would tell them to stop. This is a perfect example of one that you should enforce. So I disagree with your current attorney. And I think you need to get a meeting with that owner right away and tell them to cease and desist from building it, and explain to them that they needed permission, have them submit the paperwork, and then the board looks at it. If you deny it, you deny it. Okay, next question, number 13. Is it unlawful for a management company to give the HOA board homeowners emails? We are starting our marketing campaign to vote for our proposed CC&R, our proposed revised CC&Rs, and want to regularly share information. So this is interesting. So the management company is telling the board, I'm not giving you the homeowners emails. That is unusual. Okay. I don't know what their position is on this. I'd like to hear from them. But if you're using the emails in an effort to communicate with the homeowners about the CC&R amendments, I don't see really any issues with that. Maybe they want everything to go through like constant contact through the management company's email system. I could probably understand that. That might be easier. But as board members, you are entitled to receive this information. And as long as you're contacting them on board business, I think it's fine that you contact them. If any owner says, don't contact me on this anymore, then, you should stop contacting them. Okay, question 14. What can be done about a board with a lack of transparency? We always are preaching to boards, please be transparent. The most successful boards are the ones that communicate the most, that are transparent about problems and successes. It's just such a smarter way, a hassle-free way to run your community. But there are boards that like to hide everything and don't want to tell you things, don't want to give you information, keep you in the dark, and that's really dysfunctional. So what do? We've got a board that has a lack of transparency. You make records requests. You're entitled to do that under the law. They have to provide the records to you within 10 business days. You run for the board yourself. You try to remove the board. On our top 10 cheat sheet, number 6 is the process to remove a board under Arizona law. That's, one way to do it. Another way would be start going to your board meetings and start complaining to the board about the lack of transparency and that this is a concern. Maybe even start a petition about, we feel that the board isn't transparent, and submit it to the board. I think all of these are good suggestions to help the board become aware that, hey, this is an issue and we need to be more open and transparent on things that are going on in our community. Question number 15. Do most HOAs have architectural and budget committees? I would say probably it's 50-50. The larger associations are going to have these type of committees. The smaller associations typically have the board operate in these capacities. Question number 16. When officers are elected annually, but there are no changes in directors, does that have to be reported under the CTA? I don't think so. I think it's only if the contact information changes for them. And it wouldn't if there's no change in the directors. So no. Number 17, what about selective enforcement in governing documents? For example, acting against a non-dog owners in favor of dog owners, but not enforcing the CC&Rs that restrict dogs over 20 pounds and allow only one animal per unit. If the homeowner disputes a violation when they were cited by putting down scent deterrents to keep the dogs from pooping in front of their unit. Good question. So what is selective enforcement? It's where the board has 2 violations in front of them and they're pursuing one owner and they're not pursuing another owner. I think maybe you're a little bit different because I don't think what the situation that you're describing is you're saying that they are retaliating against you because you put down scent deterrents. So they're violating you for putting out scent deterrents. And I don't know exactly what that is, but it's your property unless it's toxic. I don't really know what it is. And it's kind of something I've never heard of. It seems something that I wouldn't really be recommending, but they're penalizing you for doing that. But they're not enforcing the restrictions on dogs, which means you've got dogs that are over 20 pounds in your community, and some owners have more than one dog, and your documents say only one dog. So I guess what I would suggest to you is this, communicate with your board about, say, hey, there's these violations and I don't see you pursuing them, and see what they say. Maybe they say some of these are emotional support pets and we are required by the law to allow these dogs. or maybe they're sight dogs or hearing dogs or, other service animal dogs. I don't know. Maybe the dogs are grandfathered. I don't know, but open the dialogue with the association about that. And, also probably as part of that, you may want to be talking with them about your issue. And I would advise you against doing that. I don't know enough about it. I don't know what a scent deterrent is, but if it's toxic, I can see why they're upset about it. Okay, next question, number 18. For those HOAs that satisfy the 6 criteria of the Corporate Transparency Act's filing exemption for large operating companies, 5 million in annual gross receipts, more than 20 full-time employees, is there any action required by the HOA other than merely not filing the beneficial ownership information? So if you fall into one of the categories that's not subject to the Corporate Transparency Act, you don't have to worry about it. And there's no other requirements other than like filing your taxes that you would be required to do. Question number 19. When I introduce capital improvement ideas, there are a few fellow board members who start coming up with the most convoluted what-if scenarios about how someone could get hurt by the improvement and sue the board. I know we are covered by layers of legal protection, but if we hire a licensed and bonded company to build it, are they taking on that risk? I'm not doing anything crazy like adding a roller coaster. Okay, that's a funny question. So you have some ideas about putting in a capital improvement, like let's say pickleball courts. And other people are saying, well, what if someone's hurt by that improvement? Maybe the pickleball court's built in a way that is, gonna potentially owners are going to get hurt, or maybe they're going to get hurt using the pickleball court. I mean, it just sounds to me like there is anti-progress, agenda by some people on your board. I mean, if you're using licensed and bonded contractors and what you're building is a capital improvement that is, something that is going to improve your community, I really don't think that these legal challenges that they're making about risks are holding any water. And I mean, I think what's happening here is they're anti-progress and they don't want to do it. So talk it through with them. Maybe you need to bring in our firm to help you talk it through with them so that we can all get on the same page. Okay, question number 20. Fines and amounts are allowed, but not specifically defined in our CC&Rs. Can we charge them at any time with board approval and without a vote of the member? So fines, so what I said previously in this presentation was that fines are authorized by state law. It doesn't have to be in your CC&Rs. So as long as you follow the procedure under state law, you are entitled to, levy fines against an owner. I don't know what you mean by amounts. Maybe you're thinking about self-help. That would have to be included in your CC&Rs in order to charge that. Okay, question number 21. We have a property management company for the past 5 years that has not done a good job of compliance inspections. So there have been lots of unauthorized ARC changes that have gone unnoticed. When homeowners do submit ARC applications that do not conform to the rules and we deny them, they point to those other owners who have illegally done similar things at their home at an unknown time. How do we enforce the past offenders? It does not seem right that we should have to inherit the sins of past boards who have not performed good oversight on the underperforming property management company. Okay, so the best advice I can give you here is draw a line in the sand. Any violations that have existed more than 3 years, you very likely are not going to be able to enforce those architectural violations. Anything in that window of 0 to 3 years, you can still enforce, and you can still deny them going forward. Like if maybe the violation is somebody's putting sheds, in their property, you can still continue to deny it. The only thing I'm going to say, the caveat is, if 51% of your lots have sheds, and you're now trying to say no new sheds, you can't do that. There's been a substantial disregard of whatever you're trying to do. And so you would have to allow that. Okay, next question, number 22. Are monetary judgments related to fines subject to a 10-year renewal? Great question. Yes, they are. Question number 23. Is it required that a homeowner be informed of who reported a violation against them? Is this a new law? So it's not a new law, but there is a law in the books that says this, that if an owner asks via certified mail for who reported a violation against them, the association is required to notify the owner who requested it by certified mail, who reported the violation or who saw the violation, who witnessed the violation. So yes, there is a law that says that, but there's a specific, like you have to meet the criteria, like you got to send whoever's asking for it's got to send it by certified mail. Okay, number 24, once you put a member on a payment plan for HOA late dues and they stop paying the payment plan, what are the next steps? So the next steps are just go legal, probably a lawsuit. With the changes in the new legislation, we do not have, the liberty of not moving forward quickly anymore. So what we say is one payment plan. If they blow it and they breach it, then you just take the next legal step. Question number 25. Is due process or the 21-day requirement notice on each letter sent a requirement before each fine process or only prior to the beginning of the fine tier plan? Additionally, for instance, in a community with a 10-day violation compliance timeframe, we would send a courtesy notice, and then with all information such as who cited, date cited, and what part of doc was violated, and include both the verbiage that they have 21 days to attest within the Arizona code, as well as the verbiage regarding the right to attest via ADR in the code, and including a statement that compliance is imperative to avoid the fines. After the 21 days has passed, I'm assuming we could then begin the 10-day enforcement and fine schedule. So do we have to wait the 21 days between each fine after the initial courtesy notice? Okay, you're making this way too complicated. The due process, the 21-day requirement, yes, it's important to have that in the letter. You don't have to wait for the fines to do that. So you can set up your letters in such a way that, you can say, you're going to be fined on this date and give them the notice opportunity to be heard. It can be less than the 21 days, and you don't have to do this big, long, drawn-out process that you're mentioning here. 26. Is it a common practice for applying a reasonable fee for processing submittals to the ARC or appeals to the board? Our CC&Rs apparently allow this. This fee must be paid at the time the request for approval or the appeal is submitted. Your thoughts? So no, it's not common practice. The only time we really see a fee is when it's a new construction on a lot. Maybe it's like a fee to have the architect review it, but this is not a common fee or process that we see. Question 27. Our CC&Rs are almost ineligible, or how about illegible to read? So most homeowners never even look at them. If we pay a contract paralegal to retype the CC&Rs, do we have to get the retyped CC&Rs re-recorded? My view is if they can't read the CC&Rs, homeowners are less likely to comply with them. So no, you don't have to record them, but it might be time for an amendment, would be my thought. If the ones that are recorded are illegible, really, we probably want to do some amendments and then re-record the document. Question 28. Phoenix City Code requires certain requirements for short-term rentals. Can the HOA require renters to show compliance? No, you can't, but you can report them to the city if you think they aren't complying. Question 29. If we can only charge $15 for not providing the tenant information, how can we force them to comply? That's a great question. I mean, that's the only way you can force them to comply. And it's a $25 fee for the application and then $15. If they don't do it, you can sue them, for this fee, but you cannot lien for it. Question 30. Thank you for the class yesterday. Okay, great. It's like you're doing double yesterday and today with me. I am a homeowner. At your class, you went over what happens when a board member breaches their fiduciary duty to a homeowner. Could you please explain that again? Okay, so a board has a fiduciary responsibility to act in the best interest of the association when they're making their decisions. So if a board member breaches their fiduciary responsibility, really what typically happens is they get sued and the lawsuit's filed against the association, or maybe the owner goes to the ADRE and files a complaint with the ADRE. Those are typically the things that happen. Or maybe there's a removal petition because the board doesn't want the board, in power anymore in the association. Question 31. We have a board president that has discontinued committees and now says a person can apply for a committee and will be possibly interviewed and will report to a property manager and not the board. What do you recommend? Well, I have to look at your documents to see what it says about committees. Like, does the board president have the authority to report committees? I mean, it's hard for me to answer this question without knowing how large your association is. So this is a hard one for me to answer, but I would look at what your documents say about committees and then go from there. Question 32. Does the 48-hour agenda rule also apply to committee meetings or just for board of directors meetings? So we've talked about this a lot internally in our firm. It doesn't say it applies to regularly scheduled committee meetings, which would be subject to the open meeting law, right? Probably best practices would be to do it, but I don't think you're required to do it under the language of the new legislation that just went into effect on Saturday. Question 33. Does it matter if our association was organized as a condo in 1979, but the units have vertical ownership, just lot number in the subdivision, but the CC&Rs refer to each unit as a condominium? Do the plan committee laws not apply to our association? I'd have to look at your documents to answer that question. It sounds like it's going to kind of depend who owns the common areas, but it sounds like even though you're called a condo, you might be considered a planned community. But I'd have to check the documents to look at that. Okay, number 34. Is there an application fee for the Corporate Transparency Act? Short answer, no. No application fee to the government. But we do charge as a firm a fee to do the paperwork for you. Question number 35. In a condo, can one owner divert or eliminate another owner's access to their main shutoff valve? Each owner has an individual main shutoff valve. To turn off water, one owner must ask for permission to cut off another's water. So, except in an emergency circumstance, there really should not be a situation where, the owners whose water is being cut off is not notified. Question number 36. Can you require a landlord to show the board that the renter has renter's insurance in case they damage the neighbor's property? So under Arizona law, no. Under your documents, no. Number 37. I was charged a billing fee and a late fee for missing a quarterly payment. I understand a late fee, but is a billing fee legal? So it just depends. Is it in your documents that they can charge this? That would be the question I would ask. If I had to guess, it's probably not in there. It's probably an add-on fee that the management company is charging. It might be considered a collection cost under the law, and they might be able to collect it that way and lien for it that way. Question number 38. By the time an abandoned home went to sheriff's sale, it took years. Then at the last minute, the owner paid up. So now it's still abandoned. Can this process go on and on? I think it shouldn't take years to get to a sheriff's sale. I mean, if you're handling it in a proper manner, it depends. If the owner was, if there was the lawsuit had the owner hired an attorney and there was, a lot of motions and we had to have a trial, it could take years. But most of these sheriff's sale type foreclosure lawsuits are handled in like 9 to 12 months. I really think maybe you need to think about a change in terms of how you approach the last one. Maybe reach out to our firm, we look at a credit evaluation and come up with a different plan, because it appears that what you did, where they brought it current, but now they're not paying again, it didn't work. So we need to come up with what our new plan is to get them to pay. Okay, number 39. Is it beneficial to file a notice of violation prior to going to the DRE? I would say yes. I think that sending out a violation letter is a good idea. Now, by notice of violation, I don't mean like, are you recording something? I'd have to see if that's authorized in your documents before I could suggest that you do something like that. Question number 40. Can our entire board conduct a tour of our development to take note of conditions without inviting the residents? Is it a meeting under the law? So short answer would be yes. If a majority of your board is meeting to do property inspections and you're talking about association business, which sounds like you are, you would have to notify your members and make it an open board meeting. Question number 41. Does the law on solar panels apply to condos or just planned communities? We want to know if the law supersedes the CC&Rs when they state the homeowner cannot make alterations without approval. So great question. So there's several laws on solar panels in associations. One is the one you cited, 33-1816, which applies to planned communities. So that particular statute does not apply to condos, but there's another one that I think it's like 33-346, something like that, that does apply to condominiums. So what I would recommend you do is, if you are a condominium or a townhome and you have an owner that wants to put the solar energy device on the roof, you need to reach out to an attorney to help you with that. If the roof is maintained, by the association, you probably have the legal authority to deny it. But we want to look at it on a case-by-case basis, because what the law says is that we can't do anything to effectively prohibit the installation of a solar energy device. So if in a condo, the roof is going to be held in common by all owners, so the owner doesn't own it. So it's typically an argument that we can make is that we maintain it as the association. You don't own the roof, and so therefore you can't have it. But again, we got to look at the facts on a case-by-case basis, because in your particular situation, you may own your roof and you may maintain it, even though you're a condo, and then we probably would have to allow you to have it. Next question, we're down to our last four. How can an HOA be run without a secretary? Well, I mean, usually we have to have officer positions filled. If you don't have the secretary position filled, maybe you could have like secretary treasurer or president secretary, have one person handling two responsibilities. Maybe the management company can step in and do the acting responsibilities of the secretary. But best case scenario would be to actually have a secretary, because they're important in that they help take the meeting minutes and they help maintain the records of the association. Question 43, can the individual vote record for board election be made transparent and open for all members to view if requested? Absolutely. And you are entitled to see the ballots too. Number 44, can a board add or change violations and amounts and fine schedules without a vote or approval of the members? So yes, they can do that at a board meeting. Last question, for the CTA, is it all board members or only officers that need to submit the information? It's all board members is what the law says. Okay, we are finished. We had a lot of different topics to cover today and 45 great questions from engaged people who were at this meeting today. So thank you so much for being here today. Really appreciate you taking the time out of your day to make your community better. Just some quick reminders regarding some upcoming events. So we have our live First Friday event where you can listen in via Facebook Live or on Zoom and have one question answered for your association. That is going to be October 4th, Friday, October 4th at 9 a.m. You can find out information on that on our website. We have an in-person class with the Scottsdale Neighborhood College on October 7th from 1 to 3 p.m. The topic is how to effectively work with management companies. You can find information on that on our website at mulcahylawfirm.com. And last but not least, our next class, number 10 in our series of classes for 2024, our October class is going to be for our Virtual HOA Academy is going to be on October 15th at 11 a.m. And the topic is going to be, we're going to do another little look at the legislative updates for this year, quick little primer on that. We're going to talk about federal laws and preventing crime and limiting liability in associations. So in that class, we're going to have a lot of good topics. So I hope you join us. Thank you so much for being here today. Lastly, I would ask if you would be willing to do so to please consider leaving our firm a Google review and or a Yelp review. We're sharing a link in the chat on how to leave a review. We like to get feedback from you on these classes and how we can do better, or if we're doing a great job and you like them. It's really important for us to get feedback, and the best way to do that is by doing a Google review or a Yelp review, so we can share that with my team and also with the different cities that we work with, so that they know that these classes are worthwhile and you want to keep having them. So thank you so much for being here today. Have a great rest of September. It's finally starting to cool off, and we're moving forward to the best time of the year in Arizona. Look forward to seeing you at future events in September and October, and thank you for being here today. Take care. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content in these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.